Hello there. Yesterday I met up with Robin Tilbrook, the lawyer who brought the case claiming that the first Article 50 extension was unlawful, so we therefore left the European Union on the 29th of March this year. And we talked about Brexit and the law. When I sat down with Robin Tilbrook, who is the chairman of the English Democrats and the lawyer who took the government to court claiming that the UK has already left the European Union due to the unlawful way that Theresa May went about the first Article 50 extension, the first question I had for him was, is his case now dead?
Well, it's we've encountered difficulties with it for sure. We first of all brought the case in the administrative court for judicial review, and after a lot of delay, which is completely it's completely in stark contrast with the kind of treatment that the Remain cases have got. But after a lot of delay, we then found that the court had made an order dismissing our case and claiming that, or certifying that it was totally without merit. Totally without merit sounds as if it's a really sort of downbeat reaction to the way the case was put. But in fact, it's actually a certification system. It's like a sort of bureaucratic tick box, which means that you then don't get a hearing. And that's really, in effect, what the judge had prevented us from getting, was a hearing. And then we had to rush about because this was done when I was off on holiday. Lo and behold, the only point where it would have been difficult to deal with it, that's when they did it. But we managed to get it into the Court of Appeal, and we then come up against Lord Justice Higginbottom, who has totally disagreed with what the first judge said, but said the first judge claimed that the extension had been done under the statutory instrument, which was passed under the EU Withdrawal Act 2018. And the second judge, Lord Justice Higginbottom, said, no, that's wrong. It was all done under the royal prerogative. And lo and behold, we were totally without merit. So we couldn't have a hearing. But then when we dug into the background of Lord Justice Higginbottom, we then found, of course, he is a member of the extreme Remainer Europhile legal association known as the European Law Institute, which is partly funded by the EU, and he's a fellow of this. It's on their website, and the fellows are basically activists for entrenching EU law and spreading and deepening its remit. So we've got a political opponent, an open political opponent, who is a Remainer, deciding the Leave case, which is clearly an instance of not having an impartial tribunal. So we've done two things. One is we've applied to the European Court of Human Rights. That's the court that deals with the European Convention, not the EU court. And we have said that the court has failed to give us a public hearing, which under Article 6 the court is required to give, or the state is required to allow us to have a public hearing. They have failed to deal with the case in a reasonable period of time. And they've also, at least as importantly, failed to provide an impartial tribunal, because we've had a judge who's actually a Europhile activist. That's one thing we've done. And the other thing that we've done is we have applied to the Court of Appeal to set aside Lord Justice Higginbottom's order on the grounds of bias. I'm actually quite hopeful about both of those. I'm just not quite so hopeful about how long all that's going to take, to be honest. But in the meanwhile, of course, Gina Miller and Scott's lawyers and so on can all get into court in double quick order to have their cases heard. But if you're trying to advance the Leave side, you meet with obstacles. But I don't think that should discourage us from doing it. We should, of course, try to fight our corner. If you don't fight your corner, you invariably lose. If you fight your corner, you've at least got a chance.
Yeah, that's one of the things that has puzzled a lot of people and angered others, is the fact that everything seems to go off at a sprint's pace as soon as Gina Miller appears on the scene. The press are there, they're all over her, they're publicising her case. Yet when it comes to a Leave-based campaign such as yours, suddenly there's just deathly silence.
Yes, absolutely right. In fact, I spoke to the Home Affairs editor of the BBC some while back, and he specifically said he wasn't going to report it unless and until we got into court. One of our people spoke to Laura Koonsberg, the BBC's chief political reporter, and she said we were blocked.
She said you were blocked?
Blocked.
So how do you take that? What do you see that as meaning?
Well, I think it's one of many instances that from the Leave side we've seen of the media being completely biased. Before the EU election, before the EU referendum, they thought that people who were Eurosceptic were a bit eccentric and perhaps a little bit of a joke. They now think that we're a serious threat, and they're just not prepared to give us any time at all. And if we get time, it's going to be entirely attack jobs, and that's what we're up against. But we are wrong if we think that what we're going to do is just. Well, they're wrong if they think that we're just going to rely on them giving us out of a sense of decency a bit of coverage. No, we're going to carry on the fight.
Yeah, one of the things that has always puzzled me, and it's somewhat really has puzzled me in the past, is that when Gina Miller opens someone else's checkbook, or if it's her own, I don't know, and spends lots and lots and lots of money on all these legal cases, but on the Remain side, we either just rely on the government lawyers, who I'm not sure about, or we do absolutely nothing at all. And as you said before, you've talked about this concept of lawfare, and the Leave side must engage more heavily, in my view, in lawfare on its own behalf.
Yes, I mean it's Leave is part of the issue, isn't it? It's part of sort of patriotic stance. People who want Leave are basically patriotic people, and they want our nation to be a proper democratic modern nation again. And really, there is a wide range of types of cases that need to be brought. Certainly, the Leave cases should be brought, and I agree with you. It's almost it's almost an indication of people sort of giving up that we haven't had lots more cases brought. The system is there. It is definitely imperfect, of course, but if we don't even try, we're like people who are faced with an invading army coming into the country, and we do nothing about resisting. We've got to resist. If you resist, who knows? You might win.
Yeah, would you like to see someone big start a campaign for a lawfare fund for that sort of campaign?
Definitely, yes. I mean, if that happens, that would be a great step forward, because that would be a situation where we were able to counterattack against all the various things that have been going on from the internationalist, globalist, multiculturalist side. And you've only got to think, just as an example of how successful this has been. All the cases on discrimination were originally being brought by that side of the political divide, and nobody was bringing anything in return. So we're now in a situation where quite a lot of academics, quite a lot of teachers, quite a lot of even people with very non-political jobs wind up losing their job simply because they are shown to be somebody who's patriotic, got traditional views, pro-leave, whatever, they wind up losing their jobs. And up until recently, there was nobody fighting for those people. And of course, what that means is that in effect, the other side win by default. It's quite strange that people haven't thought that we should fight. Of course, we should fight. Politics is actually about a fight in a sense, and we've got to be much more proactive about it.
I mean, one of the things that you are being proactive about is Facebook. Can you just tell us a little bit about that?
Yeah, so I had a profile on Facebook, and I'd had it for at least a decade. I'd never had any warnings for improper postings, and I never used it for anything that I could wind up with a warning for. They actually contacted me because they knew I was a political figure. I had to give a double identity check registration with them and give them a copy of my passport, things like that, so that I could do political adverts. And then during this case, and I think it's worth reminding people that Nick Clegg is a director of Facebook. During this case, I literally posted up the exact words, and with no comment, the exact words of the EU Notification of Withdrawal Act 2017, which was the act that said that the Prime Minister could serve a notice to get us out of the EU, and that was it. She'd got no other powers. So I posted that up. Bang! Next time I opened my Facebook page, it had gone. And it said I'd been disabled. Facebook have basically refused to explain why they've done this. And the nearest I've got to an explanation was, because I've started pursuing them in a number of different levels. One was I basically said I'm going to sue them for breach of contract, and I fully intend to, by the way. But we're just getting our ducks in a row to do that. But I got a response to the letter before action that you're required to send if you're thinking of suing from a very expensive firm of London solicitors, which claimed that Facebook had put me into a category of dangerous individuals simply for posting, it seems, the words of an Act of Parliament. And that was the only explanation I was given, in effect, for it. And then I've written to Facebook also under the GDPR, the General Data Protection Regulations, which are really useful from the point of view of campaigners who want to get access.
Yeah, I have to point out that is actually an EU-derived regulation, so that it actually, just to put things straight, the EU isn't bad in everything it does. It's just the political angle.
Yeah, well, that's absolutely right. It is an EU thing, so boo hiss to that. But that's still a tool, and it's an extremely useful tool because there are virtually no exemptions to it, and the Facebook have actually refused point blank to provide me with my personal data that they've got, and I'm pretty sure that is going to be shown to be a criminal offence under the GDPR, and I have reported them to the immediate authority to deal with that, which is the Information Commissioner. And the other thing I'm working on is to try and get them regulated by Ofcom, because once upon a time Facebook would say that they were just a platform. You could post up anything you liked, they wouldn't do anything about it. They got no control over it, and so on. But nowadays, it's increasingly clear that they're exercising an editorial control over what you're allowed to publish on Facebook. And that being the case, they should be regulated by Ofcom. If we get them regulated by Ofcom, then we've got all sorts of tools to deal with them when they misbehave. So there's a three-pronged attack: bring a case to sue them for damages. I'm going to do that. I'm pathfinding all these things. I shall publish exactly what happens and how to do it. I've done a GDPR request. I'm going to get them prosecuted over that one, and I'm going to try and get them regulated by Ofcom. And if we achieve that, then obviously we'll have got Facebook under a bit more control than it is at the moment.
And if they get regulated by Ofcom here, it might tempt the American president to start dealing with them on the same sort of level over in the States.
Well, there is talk that President Trump is going to try to regulate Facebook and Twitter and Google and so on, because they have all been misbehaving in the way that they have been acting with political bias in favour of multiculturalism, diversity and globalism, and against any patriot, wherever they be. It's not just here in this country, it's global. Obviously the President of the United States is a federal figure, and he has powers over anything that's cross-state within the United States or anything that goes outside the United States. So he actually does have some direct powers over dealing with these people. And there is talk that he's going to use that quite vigorously. And you can see why he might, because after all, the American presidential elections coming up, he needs to get them sorted out before that happens. I just must mention one other thing about the GDPR, though, because I have brought GDPR requests to the High Court and the Court of Appeal, because it turns out that on the judge's files there is a sort of case summary about each case, which the judge will read before he starts looking at any of the papers. And obviously, if that has on it something that is biased about the attitude to the case, that may actually offer an explanation for why we wound up with the results that we have. And the case summary, in other words, might be quite important, and it is written, in effect, by the civil service, who are under the control of ministers who, at the time, were all Remainers, Gawk being the chief one. So it may well be that this case summary is a sort of hostile attack on the substance of the case. And anyway, so I've done a GDPR request asking for this information. And the amusing thing is that the courts in both cases have so far come back refusing to hand over these, which raises my suspicion still further. I mean, why wouldn't they hand them over if there wasn't anything there of significance? So we've got GDPR requests, and we may well wind up with a situation where they wind up getting prosecuted for failing to hand over personal data.
Now, that would be a victory. But one of the questions that springs to mind that maybe I should have brought up a bit earlier was that if the government really wants to leave right now, why don't they just say your case won and then just withdraw their defence? Why didn't they do that?
Well, at the moment, I haven't got the case back on, so that they couldn't now agree it, just as where we are at the moment, because we've had it dismissed for the second time, and that means that it isn't ongoing at the moment. I'd have to get it reopened, which, as I say, I've already applied to do. But the interesting thing was that before it was dismissed for the second time, we got a letter from the government's lawyers saying that the new Secretary of State, Stephen Barclay, who's obviously Johnson's appointment, had authorised them to write to me and to the court, saying that they were repeating the original defence. So I think it is certain, well, as certain as you can be about anything almost, that Boris Johnson and Stephen Barclay decided that they were going to squash this case. And I think that does show what many of us suspect, that actually their agenda isn't Brexit, number one. They have another agenda, which I think is about the Conservative Party and their own interests. And that Brexit is very much just a tool for them.
Yeah, and that would be
disappointing for people to hear. At the end of the day, sort of a summary, where do you think we're going to end up but with Brexit by the 31st of October? What's your sort of gut feeling?
Well, obviously we'll find out, and we've only got 6 weeks or so to wait to see that. But I do think that it's highly significant that Boris's government didn't take the steps that they could have taken to block the Ben bill as it was then. They could have prevented that becoming law. They chose not to. And the fact that they chose not to, I think, does tell us that they must have actually quite liked the idea of the Ben bill. Now, why would they like the idea of a bill that was basically seen to be tying the hands of the government so that it couldn't actually do a no-deal Brexit? It seems to me the only sensible explanation of that is that they actually don't want to do a no-deal Brexit. And what they want to do instead is force through some variant of May's deal, which personally I think is not so much a deal, but a sort of abject surrender, unconditional surrender document. And I think what's going to happen is Parliament will come back after it's being prorogued, and it will only have a couple of weeks to decide what it's going to do. And in that time, it will be sort of kettled into, pressure cooked, whatever, into agreeing some variant of May's deal. And I think a lot of what's been going on is about setting up a situation that's going to put pressure on the Brexiteers to vote for May's deal. And I think it's worth remembering in that respect that most of the cabinet, including Boris Johnson himself, did actually vote for May's deal on the third occasion, and Rees-Mogg as well. They've all voted. So May's deal, the question about whether to vote for May's deal for them must be only a question of expediency. They wouldn't have voted for it otherwise.
Yeah, I would tend to agree with that. I think there's still a big game to play over the next 6 weeks, and there may be some more surprises to come out, and we'll just have to wait and see. Well, thank you very much for your time. It's been a pleasure.
Thank you.
Please do like and share this video, and also subscribe to my channel. And when subscribing, please do remember to press on the little bell next to the subscribe button. That way you'll get an alert every single time I put up a new video. Thank you very much for watching.